You break open a bag of chips and somehow slice your thumb on the bag itself, and now you are wondering if that is actually somebody else's fault. That question sits at the heart of nearly every product injury case, and it all comes down to two words: foreseeable use. Foreseeable use means the company should have expected you to use their product in a normal or even slightly silly way. If you use a hairdryer to dry your hair and it shocks you, that is foreseeable, but if you use it to dry your cat in the bathtub, buddy, that is on you. Courts look at evidence like the actual instructions and warning labels printed on the product. If a lawnmower says do not use as a hedge trimmer, and you use it as a hedge trimmer, you basically wrote the defense's closing argument for them. Marketing materials matter here too, more than people realize. If a company's own commercial shows someone standing on a ladder's top rung despite a sticker saying not to, suddenly that top rung starts looking pretty foreseeable after all. Internal company documents can be a goldmine for lawyers building these cases. Emails where employees say things like, "We know customers always overload this shelf, but let us ship it anyway," tend to show up in court like a guilty conscience with a paper trail. Industry standards also play a huge role in these arguments. If every other company in 1995 added a safety guard to a specific machine and yours did not, a jury starts asking some very uncomfortable questions. Then there is the classic misuse defense, which companies absolutely love to bring up. Sticking a fork in a toaster while it is plugged in is not foreseeable use. It is just a really bad life choice wearing a costume. Expert witnesses get brought in to explain how an average, reasonable person would behave with the product. They are not testifying about geniuses or daredevils, they are testifying about regular folks having a regular Tuesday. Past incident reports become incredibly important too. If 300 people already got hurt doing the exact same unexpected thing with a product, it stops being unexpected and starts being a pattern the company ignored. Social media has actually changed this game a lot in recent years. If a product goes viral for people using it in a slightly unintended but common way, that viral trend itself can become evidence of foreseeability. Age and experience of the user also gets weighed carefully. A company selling toys has to think harder about a 5-year-old's behavior than a company selling industrial welding torches has to think about a certified welder's behavior. Design alternatives are another key piece of the puzzle. If a safer, cheaper design existed and the company chose not to use it, lawyers will absolutely bring that up like it is the season finale twist. Sometimes the line between foreseeable and unforeseeable gets blurry, and honestly, that is where good lawyers earn their paycheck. It becomes less about black and white rules and more about human behavior, common sense, and what an ordinary person would realistically do. If you or someone you know got hurt by a product and you are not sure whose fault it really is, that confusion is completely normal, and it is exactly why these cases exist. The evidence is often hiding in plain sight, waiting for someone to actually go looking for it. So next time something breaks, shocks, pinches, or betrays you in a way you did not expect, remember, there might be a real legal story behind it. Want to learn more about how all of this works? Check out our links in the description.